Hello.
Here we are.
Yeah. Good
Dr.
afternoon.
Mittal,
Yeah. Good afternoon, Honourable
how are
Mr.
you?
Kirby. I'm good. How are you doing?
I don't like Cisco. Cisco
Okay.
doesn't like me.
I do get your point. Right.
However, we've made contact, so that's the most important thing. We have liftoff.
Right. Right. So there's several platforms these days, as we know. So I
Yes,
had,
Cisco always gives trouble. I never have trouble with Zoom, never have trouble with the Teams. I never have trouble with Skype, but I have trouble every time with Cisco. You must be getting it cheap.
it's not exactly about that. I mean, I do share your views because I do find the other platforms little more user friendly. I do had my own share of troubles with Cisco earlier.
Oh, I'm
But yeah,
glad to hear it.
yeah,
I thought it was
yeah.
just me.
No, 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 no. But since I'm using this now for some time, so I've got so made peace with the fact, that it's fine. It's
Yes,
pretty fine. Sometimes it gives trouble, but otherwise it's pretty fine with me.
it's
So
just the fact we've lost 10 minutes, so we
right,
just have to move on. And
right. So
whenever you're ready, I'm ready.
yeah, so I think we are good to go. Uh, Let me just introduce you, and then we'll start. So
Right.
good good morning, my dear friends in India, and good afternoon, my dear friends in Australia. Since there's a time difference between Australia and India, I'm very glad and very happy to welcome all of you today. It's Sunday morning in India, and it's around 4 p.m. or 4:30 p.m. in Australia, evening time in Australia. So I'm Nachiketa Mittal. I am founder of Virtual Law School. Some of our friends in India would already know that. And we are here today organizing Global Legal Approaches and Development Talk, a series of talk which the Virtual Law School started in the month of May. And we started a journey precisely in April 2020, earlier this year, during the national lockdown in India, to start a platform where we could teach a lot of law students in India who are not able to get admitted to the top tier one or the top law schools of the country, so to say. And the idea was to teach them pro bono or what we say low bono. So we taught around 600 students pro bono during the national lockdown in India. And after that, we shifted the model to a low bono to make the institution self sustaining on its own. And we are at the moment teaching over 20 law subjects to different law school students from across the country without any sort of a discrimination that they come from X law school or a Y law school, from a top law school or any other law school of the country, and what fee they might have paid for their degree of LLB in their law schools. So we are not a degree giving institution. We are a law teaching initiative, which is led by the law teachers. And we started with the first lecture by Honourable Mr. Justice A.K. Sikri on constitutional law. Thereafter, we were also blessed to have had support of former Judge Justice Corinne Joseph. Some of the senior counsels of the Supreme Court, like Mr. Siddharth Luthra, taught lectures on bail jurisprudence. Then some of the vice chancellors of other national law universities of India, like Professor Shanta Kumar of Gujarat National Law University, the vice chancellor, took a lecture on environmental law. So we had also Professor Yogesh Pratap Singh, who is now the vice chancellor in charge of National Law University Odisha, teaching constitutional law for last 5 months. We had, some of the other friends, Dr. Parikshit from Delhi University, teaching for last 6 months, and so on and so forth. So I'm very happy to share this journey also with you, Honorable Mr. Kirby, that this is how we began our platform and this initiative altogether. And previously on Global Legal Approaches and Development Talk, we have hosted senior counsels of the Supreme Court of India, Mr. Kapil Sibal, Dr. Abhishek Manu Singhvi, Mr. Salman Khurshid, Mr. Prashant Bhushan, former Justice of High Court of Chhattisgarh, Mr. Yatindra Singh, who is now the senior counsel. And upcoming in the next 2 weeks is also glad talk by Professor Benjamin Davis, who is professor of law in University of Toledo College of Law in Ohio in USA. and also Ms. Nana Krishnamurthy, who is founder and managing partner of Krishnamurthy and Company, law firm based in Mumbai in India. So this is all about a journey in brief, my dear friends. And now I am very happy to welcome our honorable guest, Honorable Mr. Justice Michael Kirby, for today's lecture, which is on COVID-19, virtual courts, and automated decision making. It's my pleasure to share with all of you that Mr. Kirby was a Justice of High Court of Australia, the nation's highest court from 1996 till 2009. Previously, Mr. Kirby was also president of Court of Appeal of New South Wales and also of Solomon Islands. Between 1975 and 84, Mr. Kirby was inaugural chairman of the Australian Law Reform Commission and has also had very strong ties with India. I did have the fortune of listening to another lecture by Mr. Kirby in National Law University Odisha a few years ago when I was faculty there. And I've also heard the lectures which Honorable Mr. Justice Kirby has been delivering in India. So, my dear friends, to tell you in very brief, in another minute, the today's lecture is all about explaining the impact of COVID-19 on legal practice, especially in Australia. Courts in every jurisdiction have adjusted their procedures to permit many legal proceedings by video links. These procedures will be explained. They have parallels in India and around the world too. Professor Richard Susskind in Oxford University publication has suggested that rapid adaptation by lawyers in common law countries to virtual hearings will leave a long-term impact on legal practice. It may result in automated decision making. A proposal experimented in China. Can using algorithms be used to adapt court process, or would this undermine individualized human justice that is a feature of our legal system? The speaker will explore the needs and prospects of radical change. So this has been the perspective which we have set in tone, and this has been processed and programmed by Mr. Kirby himself. So over to you, Honorable Mr. Kirby, without much delay, and we all are looking forward to your lecture. Thank you, sir.
Thank you very much, Dr. Mittal, and I pay my respects to friends in India who are listening to these words of mine. The lecture that I am about to give has been given in Australia with Professor Richard Susskind, who is the president of the British Association for Computers and the Law. I am the patron of the Australian Society of Computers and the Law, and so we had a lot in common, and we were seeking to explore what we could learn from one another. And the purpose of today's talk to India is to have you consider what, if anything, that I'm about to say is of any relevance or use to you. India has a very deep experience with epidemic diseases, and the Epidemic Diseases Act of 1897 passed during the period of is still in force, like so many of the other great codes that were introduced at the turn of the century before last. And it has been invoked in the case of the COVID-19 epidemic in India. The experience in India with COVID-19 has been, in terms of number, the second highest number of any country in the world, the highest being the United States of America, and India the second highest. But there's a big difference between the response of India and the United States to the epidemic in a per capita basis. The impact on the United States has been very much greater. And in terms of the governmental response, the response by the government of India has been much more forthright and strong, and it's been directed at lockdown and endeavouring to ensure that there is social distancing, and this has had a very beneficial consequence, that the rates of fatality with COVID-19 in India are much lower than those of the United States. All of us will be aware that the president and his wife in the United States have tested positive to COVID-19. And a large number of people who were present with him in the Rose Garden of the White House only last week have come down with COVID-19, including at least one state governor and a number of senators and others. And it's therefore a very serious issue in the United States, as it is in India and as it is also in Australia. Australia and New Zealand have some of the lowest rates of infection in the world. This is probably related to the fact that both of our countries, Australia and New Zealand, are island nations, and that means it's easier to close the border and keep people out. And in fact, there are thousands of Australians who are stranded overseas and can't get back to Australia because of the interruption in air travel and the cost of air travel. New Zealand, I think, has one of the lowest, if not the lowest, rate of infection in the world. Australia has had 800 infections that have led to death. And so it's less than 1,000 in our case. In India, according to the figures that I saw today, the rate of death is about 100,000, which is half the rate in the United States of America, where there are more than 200,000 people who have died. So this is undoubtedly a very dangerous infection, and it has had very great consequences for the economies of every country that has been affected, including India and including Australia. Our national budget comes down this week, and it's going to be a big question as to how, even with a small impact in terms of mortality, we can get our economy back on track, and in particular, whilst we continue to have strict public health laws about social distancing, the wearing of masks, the washing of hands, and all the other things that you have seen in India, and which have been successful to a large degree in India in controlling the spread of the virus. This is, of course, not the first major infection that has concerned our countries. In 1919, the so-called Spanish flu had quite a significant impact on Australia, and I don't know what its impact in India was, but it's very interesting if you look at the review of the laws that were introduced for the Spanish flu in 1919 and compare them to the laws that have been introduced for COVID-19. Many of the same things were done 100 years ago. The wearing of masks, the closure of courts, the insistence that citizens wear masks and social distancing. So in that sense, Spanish flu and COVID-19, which are both forms of influenza or of pneumonia, are rather similar, and the impact is potentially lethal and therefore very serious, and requires of the law a strong response. As it happens, when HIV came along, I was invited by the World Health Organization to become a member of the Global Commission on AIDS. That was set up in 1988, and the members of the commission, who were gathered very quickly by the World Health Organization, included Dr. Luc Montagnier of France, Dr. Robert Gallo from the United States, and other great experts in public health. Montagnier and Gallo said, we will have a vaccine within 10 years, and we will have a cure within 20 years. Well, it's more than 30 years since those meetings of the Global Commission on AIDS, and we still don't have a vaccine against AIDS, HIV, and we still don't have a cure. We have the antiretroviral drugs, which were developed in the 1990s, and which became available throughout the world largely as a result of the contributions of CIPRA in India and the development of copies of the drugs. I think India, with its highly developed skills in technology of disease control, will play a big part in the global response to COVID-19. But so far we don't have a vaccine, and many warnings have been expressed, including in India, that any vaccine that we have for COVID-19, at least in the short run, to be effective in only about 80% of cases, so that quite a significant proportion of people will slip through the net. As you would know, the annual flu vaccine, which is available in many countries, is not effective to protect everybody. It gives protection to a large cohort, but that is likely to be the same in the case of any vaccine that is developed to deal with COVID-19. Unfortunately, even the most brilliant scientists in the world, and there are about nearly 100 efforts in the world at the moment to develop a vaccine, they can't just deliver a vaccine, especially one which has been properly tested, at the demands of government. They have to go through the processes of testing and scrutiny to make sure that there are no serious adverse consequences of medications or vaccines, and therefore we don't have a vaccine yet, and it's not likely that we will have a vaccine at the earliest that is safe for humanity until sometime in 2021, likely mid-year rather than early. So this is the challenge we face with COVID-19. The first cases of COVID-19 appeared in China, in Wuhan, and they were reported within Wuhan in November of last year, 2019. They do not appear to have been reported immediately to the World Health Organization. The actual report of the virus that later turned out to be called COVID-19 wasn't made until the very last day of 2019. And that was when the Chinese Disease Control Authority reported the presence of a strange and very contagious virus, which was later called COVID-19. The net result of this was a lot of complaints by countries about China's failure to respond and to report quickly. That led to a debate in the World Health Assembly in March and April of this year, and that led to the establishment of an international committee which is being chaired by the former Prime Minister of New Zealand, Helen Clark, to try to derive what are the lessons that we can draw in the international community for disease control as a result of our experience with COVID-19. But by about April of 2020, the world was addressing very directly and very urgently the problem of COVID-19. Emergency regulations and additional and supplemental regulations were adopted in many countries, and they included India and Australia. And it was to discuss those developments that Professor Richard Susskind and I had a webinar about a month ago to see what lessons we can learn from the way in which the United Kingdom and Australia and other countries had reacted to COVID-19. And in both the United Kingdom and the United States and Australia and in India, courts had reacted quite quickly, actually, to the existence of the epidemic and the challenge that was presented by lockdown. In the High Court of Australia, which is the Supreme Court of Australia, where I sat for 13 years until 1996, the court had previous experience with audiovisual links. The special leave applications in Australia to have a grant of special leave to bring a case from the state courts or federal courts into the High Court of Australia were, from even before I was appointed to the High Court of Australia in 1996, conducted by audiovisual link. And that meant that on my first week serving on the court, I had to sit in the number 2 court in Canberra and for the first time speak by audiovisual link to barristers and solicitors and clients who were sitting in a courtroom in Darwin or in Perth in Western Australia or in Hobart in Tasmania. And it was really surprising to me how quickly the human mind adapts in a courtroom where you're so totally focused upon the presentation of your argument that you forget that you're doing this in a rather artificial circumstance, talking to a screen, as I am now, and you just get on with the job. And so that is what has been done in Australia for more than 30 years. And therefore lawyers in Australia appearing before the highest court have become quite used to presenting through distance and by audiovisual link. I don't know whether that has been introduced in India. I've seen your applications equivalent to special leaves in the Supreme Court building in New Delhi. I don't think you have audiovisual links, but in a big country like India and with centres of courts in different parts of the subcontinent, it's surprising that that hasn't already been done. And I would suggest that it's very likely that this is going to be a consequence of the use of audiovisual links in the courts in India. The audiovisual links are not in normal times used for argument of appeals. They are only used for special leave applications where lawyers are given 20 minutes to argue their case, and then comes the chopper. If they don't get special leave, they're finished. If they hear the other side, then it takes another 20 minutes, and then the decision is made. But there were weaknesses in the system, in that, for example, prisoners who were in prison could only appear by counsel, and that was a disadvantage that was suffered by prisoners, which I always objected to. In India, I remember my friend and colleague, Justice Bhagwati and Justice Krishna Iyer, introduced the epistolatory jurisdiction and receiving letters and informal process from prisoners in order to get a hearing. But this is something that audiovisual links have to develop with, and not simply be there for the convenience of judges and lawyers. Courts are basically there for the advantage of the citizens, and that it was a weakness that I called to attention in a number of cases in Australia long before COVID-19 came along. In the Federal Court of Australia, they have introduced the system of audiovisual links available for hearings, including leave applications in that court. These links have been quite successful. There have been a number of weaknesses of them. Getting a transcript from the audio-visual link is more complicated and takes more time. And sometimes, whilst parties are given access to the link, the members of the public are not always given access. And it's very important that the principle, which has been observed in common law countries, of limiting very strictly the closure of courts and insisting on the availability of courts to the public, that principle should be preserved even in the time of COVID-19. In Australia, the litigants and the lawyers are given access to the link, just as I had access to take part in this dialogue today. But members of the public were not given access, and they had to phone in to the given number of the judge's clerks in order to be given the number, and that is a limitation on the availability of the court proceedings to members of the public. So that is something that has to be watched and improved. In the state Supreme Courts, which, like the courts, the great courts in India of Bombay, Madras, and Delhi and Calcutta, are royal courts set up in the 1800s. Those courts have also embraced distance advocacy, and the Court of Appeal of New South Wales generally has one judge sitting in the courtroom of the Court of Appeal, and two other judges are sitting in some other place, usually their chambers, but sometimes apparently at their homes. And the Court of Criminal Appeal in the different states in Australia generally is seen sitting, the three judges sitting together. The state courts, unlike the federal courts in Australia, still wear wigs like the English, and still wear red robes on criminal days, and the three judges will sit in the Court of Criminal Appeal, and the counsel will be somewhere else, perhaps in their lawyer's office in the suburbs, and making their submission. And in some ways that has been better from the point of view of the client, because the client if not in custody, can sit in the body of the lawyer's office and see directly into the court and hear the argument and hear of the disposition. The state courts normally conduct the criminal trials, and the criminal trials in Australia involve jury trial, and it has proved rather difficult to combine AVL linkages to jury trial, and basically where it hasn't been agreed that the criminal trial will proceed by judge before a judge alone, the cases have just been postponed, and this has been rather very unfair to prisoners who are in custody awaiting trial, and that has led to increased applications for bail pending trial, so that the prisoner is not suffering the double disadvantage of being in custody and being in a former custody, a custodial custody, where there is a likely increased risk of exposure to COVID-19. In the United Kingdom, the Supreme Court ceased actual hearings in March of 2020, and the Supreme Court proceeded to hear most of all of the business of appeals by AVL, audio-visual linkage, and that has proved quite successful, according to Professor Susskind. He is the consultant to the Lord Chief Justice in England on audio-visual links, and he says that this has been a big success, at least in appellate courts, more problematic in trial courts, but in appellate courts, the only complaint is that the judges say that they miss the opportunity of informal discussion and discussion about the case, probably a discussion and gossip about the lawyers and how hopeless they were in the particular case. But that's one of the disadvantages of audiovisual links. But they have been quite successful in the UK, surprising the judges who, unlike the High Court of Australia, didn't have these audio-visual links for the special leave. That was just something we had in Australia because our country is so big, and this was an efficient way of dealing with matters. In the Supreme Court of the United States, they've always been very resistant to cameras in the courts. Probably they know enough about the misuse of media that they don't think that that would always be to the advantage of information, and they have resisted it. But under the pressure of COVID-19, the audio but not visual record of the proceedings before the Supreme Court has been released. They've always kept an audio record of the argument of cases in the United States, but that generally gets transferred into the archives and isn't available to the general public for quite a considerable time, 30 years, I think. But people were amazed during the earlier months of this year, hearing the late Justice Ruth Bader Ginsburg asking sharp questions from her hospital bed, and that was just something that could be done with AVL that couldn't have been done if she had had to be at the courthouse. So this is the good news, and it's led Professor Susskind to say, well, all these lawyers are getting used to the procedure of distance communication. Maybe the lawyers are ready for the next step. And this is Professor Susskind's thesis. He says the common law system is very good for neutral determination by independent judges, and that is a great tradition that we've inherited. But it is very slow, it is very cumbersome, and it is very expensive. And he says what we have to think, having adjusted our brains to sitting in a communication through a video screen, we've got to think of the next step. And his thesis is that the next step is that we will use the analysis of algorithms that can now be undertaken by computers to examine the way in which the majority of judges deal with particular cases, and we can so prepare the matters for legal determination that instead of the judge being a neutral decision maker in the court, the judge's job will be to shepherd the lawyers to the applicable law, and that will be done with the assistance of computer analysis, which is based upon the text of the relevant code that is in play, and analysis of the facts by the computer, analysis of the standard conclusion on the facts in other decisions that have been handed down by the courts, and that all of this will be a way of expediting and cheapening, making much more cheap and inexpensive the procedures of the courts. Now, I know in India, and it's also true in Australia and other common law countries, that we have huge backlogs of decisions in the courts. And of course, this suggestion of Professor Susskind is very popular with those who are critical of the courts. It's less popular with lawyers, and both in the United Kingdom, where he operates, and also to lawyers in Australia, when he put forward his proposal, they didn't like that suggestion much at all. And they pointed out that a very important feature of our system of the independent neutral judge is the freedom of the judge, especially in appellate courts, multi-member courts, their freedom and indeed their obligation to express their truthful conclusion and not simply to go along with what others have said before, or that others are saying now, or that the majority say now, if they have a different point of view, and they can explain that in their decisions. The right to dissent has always been a very important feature of the common law system. It is not a feature at all of the civil law tradition, that is the European system. In virtually every European country, there is no right of the judge to dissent. And a very curious thing happened last year in France, when a law was introduced and passed by the French Parliament to prohibit analysis of algorithms for the purpose of guiding the lawyers and others, and media, on what will be the outcome of a case. The capacity to use algorithms to examine judicial decisions is not at all unknown in countries of the common law. It's well known and has been around for at least 20 years in the United States, and it's available in Australia, and there is nothing to stop people analysing publicly given decisions, and I'm sure in India there would also be analysis of the decisions of the courts. But the French don't like this at all. And they don't like it because they have the view that the judge is just, as the French call it, la bouche de la loi, the mouth of the law. The judge is nothing more than an automatic expression of the law. And that is so important to the French notion of law that they're very unsettled by the idea of having analysis of algorithms in order to predict the law. And indeed, they've imposed a criminal punishment of 7 years imprisonment for doing that. So this is something which common lawyers find very, very curious indeed, because we've lived for centuries with the right and obligation of truthful expression of your point of view. I often think of one of the great cases of the High Court just before I came on the High Court of Australia, which was called the Mabo case. It was Mabo against the state of Queensland, and it concerned a challenge in the High Court of Australia to the refusal of the Australian common law to recognise the land rights of Indigenous people. They were not recognised in the law, and Indigenous people in many countries, including Canada, New Zealand, Australia, and no doubt India too, have suffered disadvantages in the law. And in that case, which by the way was argued by a tax lawyer, he wasn't a big human rights lawyer, he was a tax lawyer. Ron Caston, his name was, and he argued the case of principle, and in that decision, by 6 justices to 1, in a court which is made up of 7 justices, the court reversed 150 years of land law and said that was a mistake and that it was based on racial discrimination and it can no longer be part of the law, and that that had to be changed, and Australian law does recognise the Indigenous people's right to their land. Now, that would never have been decided by an algorithm. That would never have been decided by machines. That required human judgment and human appreciation and human reflection on the importance of justice. And so these are the controversies that are likely to come before us in the aftermath of COVID-19. Professor Susskind said, lawyers have had their minds opened up to the great value of the new technology. And there's no doubt about that, and there's no doubt that we will increasingly use the new technology after COVID has disappeared to facilitate access to the courts and to bring the people into the courts in a much more effective way, hopefully bringing the public with them as well. But the idea of turning everything over to machines and to algorithms and to computer analysis of the decisions of the majority of people is not something that is immediately attractive to somebody who is brought up in our legal tradition. There is much else that could be said about this, but that's as much as I want to say today. I've told you about epidemics in the past, the HIV epidemic, and that makes one cautious about predictions of a quick vaccine or cure. I've told you of the way COVID-19 came about, and the countries that have done best in responding have been the countries that have addressed the lockdown and have put a great store on human life and protecting the lives of people, even at the cost of the economy. And the developments within the court systems, including in India, have encouraged and facilitated links by audiovisual means. But whether we will go the whole way with Professor Susskind and turn over our courts and send lawyers off to jail if they look up the algorithms for the tendency of the courts in the past is another matter. And I think that's something which members of the audience will want to consider in the context of India, where the backlog problem is a very great problem. It's the backlog that has led the Chinese legal system to use algorithms and to use tribunals and not courts in order to make justice move much more quickly. And therefore, I think this is going to be something that you will have to address more even than Australia in the future. So that's what I wanted to say to you, and that has been of some use, and I hope that there may be some questions.
Right. Thank you so much, Mr. Kirby, for a wonderful lecture. And I did take points myself, noting here down some of the very interesting insights that you've shared, that how it's not just about the virtual courts, which are far more necessary reality for in the coming times, and especially during the COVID times, and how in Australia, since last 30 years, you have been using yourself, video conferencing and audio visuals for the purpose of proceedings. So surely, I mean, there was some traces of these things in India, but not in such a profound way as we see today. So, but now since the national lockdown, all the courts in India have been working as virtual courts, from the Supreme Court to the all the lower courts in India. And in 2018, I'm happy to tell you, in 2018 we had one of the judgments coming out of the Supreme Court about live streaming, about broadcasting the Supreme Court proceedings. So it was a judgment delivered by former Chief Justice of India, Honourable Justice Deepak Misra. It was actually a petition filed by one of the law students who was not able to access to the court proceedings. So, but then the guidelines were framed and so on and so forth. They've been all efforts done in the recent past to also make the Indian Supreme Court and Indian courts coming up with the technology used like all other major common law countries. So that's certainly a major progress that's been done, and falls
this
within
was
the
Justice Misra, who
right.
was at the university in Bihar when you and I first met. Is that correct?
University of
He was the
University of Odisha.
Orissa, yes, that's
Right,
right.
right,
Oh, yes,
right.
Orissa.
Yes, yes,
He was the chancellor of the
yes,
university. He
exactly.
gave me my honorary degree.
Oh, wonderful, great.
Yeah, and what did he say? Did he say that they could have, because in the High Court of Australia, we had a discussion amongst our judges, and I favour of allowing the broadcasting, as they have in Canada. The Supreme Court of Canada has a dedicated channel for it, but most of my colleagues were absolutely opposed because they thought barristers and maybe even some judges might misbehave. They didn't have confidence in allowing it. So it's not permitted in Australia and it's not permitted in the United States, but it is permitted in Canada.
Right. So we then frame the Supreme Court frame the guidelines for that, because I agree there will always be a lot of challenges in just simply allowing it, because it's at the end of the day what transpires in the courtroom sometimes becomes quite sensitive also. Right. So they have to be certain guidelines which the Indian Supreme Court has also developed. I am yet to look into that myself. That how that's being processed at the moment. But
Yes,
we
well,
did
keep
have
me informed on that,
sure,
please.
sure. But we did have a major breakthrough in which this was read as part of the major access to justice discourse. That is going to only widen that kind of horizon, not going to dilute it in anyhow. And however, the only point was that if there could be proper guidelines framed, so then it's certainly a possibility. Now, at the same time, I was very intrigued to hear in your lecture about how you referred about Professor Richard Susskind and different kinds of insights shared by him. And definitely there are going to be certain pitfalls, certain kind of challenges which the virtual courts may not be able to look into by virtue of the automated decision making. For instance, the case of the indigenous communities and so on and so forth, because there can be certain peculiar aspects which the automated decision making may not be able to capture, and we may actually require very personalized, individualized sort of a decision making by virtue of sometimes judges, knowing the cultural, perspectives and conditions also much better than what can be fed into the algorithms.
Yes,
Right.
I agree with that, but I think sometimes judges have to unlearn the cultural aspects
Hmm.
because sometimes bound up in cultural background are prejudices and attitudes that are quite difficult to change. And this is definitely true in Australia and indeed in all of the settler countries of the common law. New Zealand with the Maori, North America with the so-called American Indians, and South Africa, the prejudice against people. And you in India have prejudice in the caste system, and maybe the fresh air of availability of the whole community to see these issues debated is by transparency, the way that courts, as great educators of their community, can lead the community to fresh thinking, because cultural attitudes can sometimes be out of date. And this is often the way with the law relating to women, with the law relating to Indigenous, the law relating to people of different race and religion, and the law relating to sexual minorities, LGBT.
Right, right. I do agree. They are these kinds of challenges, but at the same time, you're right that even judges come through varied backgrounds. So there's a lot larger process of sometimes unlearning as well, which is always a sort of a sensitive and a critical debate in the judicial discourse. Right. So, if Honorable Michael Kirby, if you allow, we'll take a few questions from the participants. So
Yes,
if
certainly.
there are few, so I'll request the participants that you can type your questions in the chat box, and we'll be happy to route it through for on your behalf. And some of you who may want to speak, switching on your microphone, so I can allow that as well, because I understand that you may really want to have your sort of a dialogue with Mr. Michael Kirby. Yeah, so please feel free and let us know. Take a minute so that the questions can be answered.
There is a column on the right-hand side of the screen which
Right,
has Q&A,
right,
but people are so overawed and amazed by what I have to say that there are no questions. You should be typing in some questions yourself, Dr. Mittal,
right.
and ask me a very difficult question. Just whilst we're waiting, Professor Susskind
Hmm.
says that it's going to be all the old conservative judges who don't want to change anything, but I'm not so sure that that is always the case. Sometimes you have to change, but on some issues, you may not want to change. For example, imprisoning somebody because they do an analysis how judges have voted on constitutional cases, sending a professor, learned professor of law, away for 7 years in prison because he started to analyse the predictability of the judge, seems something that is not very congenial to us in India and Australia. It's just not our way of doing things.
Right, right. So since you have been using the technology for a very long time, as you've said that ever since you went to the High Court of Australia, to serve that for almost 30 years. So I would really want to know that in this entire context, that what has been your experience that if we, for example, take different kinds of variety of branches of law in cases, so how far would the virtual courts and the automated decision making be useful when it comes to dealing with the cases of human rights? They can be, different kinds of violations of human rights. So, how are these going to be useful, or do you think that these are actually going to create some kind of challenge, and only the personalized, the judicial opinion, as we see the regular setup, would be a better idea?
I think that human rights cases are well adapted, certainly on the appellate level, for determination by audiovisual link. In fact, I don't think audiovisual link is a big deal at all. I don't think it's a big challenge. It's a way of bringing people outside the courthouse to the mind of the decision maker. And I think that that is something that is generally beneficial. The problem in Australia in this respect is twofold. First of all, the problem of jury trial, because in serious criminal cases, we have the system that 12 citizens are brought in and they decide whether the prosecution has proved the case beyond reasonable doubt. And that's actually one of the few guarantees that is in the Australian Constitution. And most people in Australia think that that is a good thing because it means that the criminal cases are ultimately decided not by learned judges, but by ordinary citizens. It's a democratic feature. But the other problem is for trials, where you don't actually have the witness before you, and you have to try to judge the veracity of the witness and whether that will be made more difficult by audiovisual links. I'm not so sure that that is going to be a problem, because I can see you and I could tell with the expert judicial eye that I developed over 34 years as a judge if you were trying to fib. And if you were trying to pull the wool over my eyes, Dr. Mittal, I would know at once, because I can see you very clearly. Probably I can see you and hear you better than in some of the old courtrooms. I mean, the old British courtrooms were very magnificent and beautiful, but often they were very difficult to hear and to see witnesses at a great distance. So I don't think that there's much of a problem with most trials, including human rights trials. And in any case, if this is a way that we can bring people to justice, that's a good thing. But I myself disagreed with my colleagues about prisoners. I said the prisoner is in a prison. Bail applications are made from prisons all the time by video link. We are not so grand in the High Court of Australia in Canberra that we shouldn't be willing to listen to a prisoner. He'll only get 20 minutes, and if he's wasting time, the court can take charge of that. But because he's in prison, he shouldn't lose his right effectively to put his case. And so I, in a case called Muir against the Queen, I said that that is something that should be available to prisoners, so that they have a real capacity to put their case to the highest court. But that was a bridge too far for my colleagues. They didn't think that was a good idea. They didn't want to be sitting there listening to prisoners. But Justice Krishna Iyer was one of my teachers, as was Justice Bhagwati. And in a way, you judge the fairness of a legal system by how it treats the most lowly. And prisoners are amongst the most lowly. And I think that's something you learn if you have yourself been the subject of discrimination. And in a future webinar for virtual law school, I hope I can come back and talk about the issue of LGBT rights, because that was an area where I was the subject of discrimination in the law, and it's only for the people who have been discriminated against that people who are judges who have lived rather wealthy or better economic lives can understand the viewpoint and how damaging discrimination is for everybody concerned.
Right. Right. So, in fact, I would be very happy to have that another lecture on LGBT rights. And as you know, in Tej Singh Johar versus Union of India, a few years ago, we have made a major breakthrough by
Yes, indeed.
decriminalizing.
And that was Chief Justice Misra.
Yeah, that was Chief Justice Misra.
Decision here.
Oh, great.
It's here. That's the decision of Johar and the Union of India.
Correct. Right.
These are the ports of the Commonwealth.
Right.
Just close to my desk here.
Right. Great. So we have few questions here in the chat box as I was speaking to you. So Katyani, do you want me to switch on the mic, and do you want to speak it take it by yourself, or I can read it out on your behalf? So okay, let me switch on the mic so that the participants can have fairly good sense of connection, speaking directly. Yeah. So Katyani, you can speak. I have unmuted you.
Hello, sir.
Yes, good morning for you.
Yeah, good morning, sir. How are you doing?
Good.
So I wanted to ask you regarding this automated judicial decisions only. How far do you think these automated judicial decisions would remove the societal bias? Like we have gender bias, we have caste-based bias and religious bias. And how far this would promote equality and secularism in our country or worldwide?
Well, that's an interesting question, and it's perhaps interesting that the place where the use of automated decisions has been begun is in China, and this has come about because of the backlog. But it may be that an incidental consequence is that you can remove or reduce forms of discrimination that can creep in by individual decision makers. But it's quite interesting for us in India and Australia to look at the demonstrations in Hong Kong. They were demonstrating against the security law that was going to turn over their security cases to judges in China. And they said, many of the young students who were, the number of people who are acquitted of a criminal case is less than 1%. And therefore you might remove the individual decision making, but you might also introduce effective governmental control, because nobody, no judge is willing to stand out of line. You have great judges like Justice Bhagwati and Justice Krishna Iyer and Chief Justice Misra and all of those who've been my friends in India, because they were independent. But this is the challenge. I do understand, and I've been following the debate in the last couple of days about the rape case in India and the disposal of the body of the victim of the rape. So this is a big issue in India, and how you tackle it is something you have to address. But the issue of automated decision-making may be suitable for some things. For example, do you have a right to a pension or something like that, which is determined by specific entitlements, and have you ticked all the boxes? It may be it's suitable for a thing like that. Nowadays, if you think about it, we go, when we can fly, to the barrier at the Indira Gandhi airport in Delhi, and it's all basically by algorithms and by automatic decision making. There's not much room for discretion on the part of the migration officer. It's in your electronic passport, and that applies the law. Does the person, is that from a country which we allow in? Is that a person who has a visa? How long is the visa operating? Is it operating now, or has it been cancelled? COVID-19, all of these things can be done automatically. And so I think there are some things that can be facilitated, expedited, and depersonalized. But as with the Mabo case, there are some things where we positively want them to be personalized so that the spirit of justice can play a proper part where that is appropriate.
Right. Thank you so much.
Thank you so much, sir.
Right. So we have another question coming up from my colleague that it reads, hello, sir. Thank you for such an enlightening session. I would like to ask, what are the challenges to make the court proceedings public through dedicated television channel as we use for parliamentary proceedings, which probably would make justice more transparent?
Well, that is what I myself said. You are going to be a great advocate. I can see that, because you put forward my arguments very well. But my colleagues, what were they? They were concerned that instead of concentrating on the case, the lawyers might do grandstanding, and the judges might do grandstanding. And instead of being people who are focused entirely on the legal case, they might be showing off. And we have to acknowledge that with lawyers, there's always a risk of showing off. But you've got to, in every problem of this kind, you've got to balance the risks against the advantage. When I did an economics degree, I learned you've got to balance the marginal cost and the marginal utility. And the marginal cost is of a lawyer or a judge showing off. The marginal utility is you open the highest court of the land to millions of people. And this is their court, and it makes decisions that are affecting their lives. And it makes it more transparent, and people can understand. And even if they don't agree with it, they feel as though they're engaged with it because they've heard it argued, and they know that the matter will be considered by very clever and people with all of the relevant matters in the arguments of counsel. So my own feeling is that, yes, there was a risk, but it would be outweighed by the transparency, the value of transparency, of bringing the highest court to the people of the country.
Right. Thank you. So there was another question which is quite similar to what Katyayani asked, though. I'll, however, read it out. Sir Shikhar Tiwari wants to know that, sir, the recent AI techniques make use of established databases for decision making, so they may carry cultural experiences and bias with them. What do you think about implementing automated decision making of subordinate courts handling preliminary proceedings, which can later be appealed if needed?
Well, having the facility of appeal is a protection against a misuse of a power. And that is always a relevant consideration in any legal system. And that's why it's very important to protect both the right of appeal and the right of judicial review. These are very important protections and guarantees that we have inherited. But on the other hand, the law is often very complicated. For example, there's a good article in the latest issue of the Criminal Law Journal in Australia, which says, we acknowledge that there are problems with automated decision making, but so long as you keep the matter available for a review by judicial review or by appeal to a live human being, there are many risks in, say, sentencing of a prisoner or a sentencing appeal, that the judge might overlook one of the many provisions that are provisions of law governing sentencing. They said, and it was surprising to me, that some sentencing decisions have as many as 123 legal provisions that the judge has to take into account. And if you had an automated decision-making process that dealt with that and reserved the final decision to the judge, that might be a way of making sure that the judge doesn't overlook a particular issue, but reserves the final determination to a human decision, so that it can deal with any circumstance which needs to be taken into account in order to reform or re-express the law where it's got out of step with changing attitudes. Those changing attitudes might be in relation to Indigenous rights, might be in relation to racial rights, or to religious rights, or to gender rights, or to sexuality rights. And therefore you need to have a fail-safe, but just the same, the automated process could surely be used to make sure that tech requirements are all dealt with and not overlooked, because that's always a risk in any judicial life, that you miss a point. I've missed a point in my time as a judge. If you're human, you're going to miss points, and maybe the new algorithms will help to deal with avoidable error.
Right. Thank you so much. I do agree that there are certain areas where the human error could be, done away with by using the automated decision making. And it has got its own positives and negatives at the same time. But as I believe, it is about harmonizing both the things together, how and where the individualized decision making becomes actually non-negotiable. And there are areas where we can probably, for the purpose of wider reach of access to justice and faster disposal of the cases, as you know, even in India and even in most of the common law countries, the decision making has always been an area of concern, with the dockets of the courts being flooded with the cases. So probably in that realm, automated decision making can ease the burden for the courts, and there can be certain category of cases which can be earmarked to be dealt with the automated decision making based on algorithms, based on certain testings, and probably based on certain results which can be verified, that if those results could be similarly achieved by the individualized and in the regular kind of courtroom decision making, so how much time it would have taken, what would have been the cost involved, and what would it in fact incur as a loss also sometimes probably. So all of that kind of a combination could probably be studied. I'm sure it's just a very nascent stage for all of us in that sense of automated decision making across the world, to arrive at a conclusion which can be universally be applicable. So, but yes, it's a major learning forward, and I'm looking forward to read some of these articles, as you have mentioned, also from the Criminal Law Journal of Australia. That what are the problems, which have been probably encountered and reasoned out by the author there. And so I'll touch base with you separately on that if you could share that article. So it can be, we can use it for our students in circulation.
Yes, I will do that.
Right. So as we were speaking, even in last several weeks, and we're planning for the Glad Talk. So, and you have mentioned it today. It will be an honor to host you again for the perspective sharing, discussion, deliberation, and knowing your thought that how what has been the changing regimes with regard to LGBT rights across the world globally, and how do you see the comparing situations in India and Australia? Right, so we can plan it in the days to come, for which.
These were my Tagore lectures, and that is on sexual orientation and gender identity, a new province of law in India.
Right.
And this is published by Universal Law Publishing, and it's brilliant, even if I say so myself. And this deals with, and this was before the decision in Johar.
Right.
And I pay respects to Chief Justice Misra, who wrote a wonderful decision. In fact, all 5 decisions of the justices of the Supreme Court of India in Johar are wonderful decisions of a free country which is willing to look afresh and with the flame of liberty and equality at an area of the law where that has been missing in the past. So I'll make sure you get a reference to this. Maybe it'll sell well in India, and you can promote it through the virtual law school.
Surely. So thank you, Honorable Mr. Kirby, for a very enlightening, very enriching lecture today. Something, an area which we all are grappling with. All the common law countries are grappling with this kind of a challenge today. It's not just that one or the other country is going to undergo this kind of a crisis, and we don't know that what is going to be in store in the future for all of us. How long the COVID situation is going to create obstacles in the kind of decision making that we have been seeing, and especially in the countries like India and many others of similarly placed societies and countries where the population plays a major role, where the courts dockets which have been full for a long time need to be cleared up. So probably the automated decision making can be experimented and used as a means to provide faster disposal of cases and access to justice.
Just don't try to do it in France.
Right, I agree. So in fact, I'll try to do my share of research on that as well. That how we are starkly different from the European and the French in that sense of how it's been criminalized, as you have put forth, that 7
years.
Right. So that sounds quite barbaric in its sense, because it's at the level we are talking from the common law country's point of view. There appears to be definitely nothing wrong in that. It's about facilitating justice delivery at the end of the day. Right. So thank you. It was a pleasure hosting you today. It was an honor hosting you today. And we look forward to another set of lecture from you in the coming weeks, and for which we will plan with you separately. And all my dear friends, law scholars, law professors, judges, law students who have been watching the program, the virtual law school today. It was live streamed at the Facebook page of virtual law school as well. So I'm sure you would have taken back with you today great insights from the lecture, and we look forward to your best wishes and blessings in making virtual law school a reality, to reach out to a lot of law students who otherwise probably are not able to get access to online law classes and legal education by virtue of the technological infrastructure challenges that most of us are facing today. An idea behind virtual law school, as all of you know, has been that every senior professor, law teacher who has been coming and teaching at the virtual law school platform has been teaching completely pro bono. And the trend has been set by some of the finer judges like Honorable Justice Sikri, Honorable Justice Korean Joseph, Mr. Siddharth Luthra, who is a senior counsel in Supreme Court, and some of the vice chancellors and professors. And I'm glad that we have only been growing in that number of a lot of senior professors coming forward and teaching. And in the coming weeks, we'll have law of evidence classes by a vice chancellor, Professor V. Kesav Rao of National University Ranchi, also teaching some of the classes of law of evidence. So, my dear friends, stay tuned with our journey. And it's been 5 months since we started off, and it's been a good learning process, and we have been able to contribute in our own way. So thank you, sir, for joining us today, and we look forward to your blessings and support in future as well.
Thank you, and I look forward to the next time.
Right. Thank you.
Thank you, Dr. Mittal.
Right.